Yes.
I think I'm done.
Very well. I'll proceed to give the floor to the Deputy Ranking, Honorable Patricia Apiaje.
Right, thank you very much, Mr. Chair. Honorable nominee, going by your CV, I'd like to ask a question, because if I look at the time that you were born and the time that you entered secondary school, I'd like to find out, at what age did you enter the secondary school?
A little less than 12.
Specifically?
I went to the secondary school in 1970.
Yeah. So we presume that you entered at the age of 11. 11
plus some months, please.
Thank you very much. I found it very interesting because at that time we had people entering secondary school at the age of 13 and 8. So I found it very interesting.
Luckily, my father was a head teacher, so I...
Right, thank you. Honorable nominee, how many judges do we have at the Supreme Court currently, practicing judges, and how many are women? I'm talking about current one. How many are women?
Currently, we have two, Justice Avril and Justice Mensah Bonso. And then the CJ Justice Tokono, 3.
And how many in total, please?
13.
13. Thank you very much. Honorable nominee, I'll proceed to bring to your attention that last year, 2024, exactly in June, the Gender Equality Act, Act 1121, was passed. One of the questions I want to put to you at this point in time is that this act mandates gender parity in public appointments. And Article 144 requires merit-based judicial selection. If these provisions conflict, for example, if achieving gender parity requires appointing a less qualified candidate, which takes constitutional precedence, and why? Which of the two? I've given you indication of the constitutional and then the legal aspect of it. Thank you.
Mr. Chairman, as much as possible, you should send the best to the Supreme Court, or you should appoint the best wherever. You don't use the gender equality thing to appoint somebody who you think is not qualified, but because of gender. So I will always go for the quality. If it means one person who is qualified, fine, go for that person. Don't say because of gender. If the person is not suitable or qualified for the job, you appoint the person to satisfy gender equality or gender parity. Thank you.
Thank you very much. So, to follow up, I would like to find out, what would you suggest should be the best approach in ensuring the achievement of the gender parity as it exists in the law? Thank you.
Mr. Chairman, if a lady qualifies, or yes, if a lady qualifies for a position, why not? Gender parity does not necessarily mean that you appoint women to satisfy the numbers. No. If the woman is qualified equally as the man, then when you are appointing, you look at that. You don't give the chances to men as against women. But that does not mean that you push ladies who are not qualified for the job to satisfy that parity. Thank you.
Mr. Chairman, I think I need clarity on this because I asked a specific question. What would you recommend should be the approach to achieve that? Thank you.
Madam Chairman, if you pass me through and I get to the Supreme Court, then maybe when it comes, I can then recommend, but as at now, I cannot recommend anything. Thank you.
Any further question?
Yes. Thank you very much. Honorable nominee, one of the issues are constitutional interpretational issues that we have faced. In the 1992 Constitution, it guarantees equality before the law and prohibits discrimination, as you rightly said. Given that approximately about 35% of Ghanaian couples cohabitate, how would you reconcile the constitutional principle of equal protection with the current legal framework that denies cohabitants the same rights as married couples? Should the Constitution's equality provisions extend to protecting cohabitants from legal vulnerability?
Mr. Chairman, as at now, what the Constitution says is what we have to do, because whatever we say beyond the Constitution is noise. And no matter how many noises you make, what the Constitution says is what overrides. Thank you.
Thank you very much. There's also another aspect of this issue of cohabitation, and it has been realized, and there's every indication that women in cohabitating relationships are highly vulnerable. They are highly vulnerable, including higher rates of intimate partner violence and economic insecurity upon relationship dissolution. How should the court balance respect for traditional marriage institutions with a constitutional mandate to protect vulnerable population, particularly women who may have contributed significantly to households but lack the legal recourse? Thank you.
Mr. Chairman, what is the question, please?
The question is that we've observed that women, a large number of women are in cohabitation relationships, and these women are highly vulnerable. They face violence, and most of the time they even contribute to the well-being of that relationship, but they are not recognized in law. And therefore, it is important that we also look at their vulnerability and protect them. What is your view on that?
Thank you, Mr. Chairman. We can't give hypothetical solutions now. Maybe if I get to the Supreme Court and a case like that comes to the Supreme Court, then we'll look at it on its own merits and then maybe evolve some case law to take care of such situations, please. Thank you.
Ranking member has a follow-up question on that. But let me bring it to the fore that we are yet to pass the cohabitation law.
My Lord, the exchange we're having is for the good of democracy. I would encourage you as much as possible to yield to the hypothesis in this discourse and express a view, because once you start getting into the arena of when I go there and then unless case by case, then it becomes difficult, and I'm sure everything will come to a standstill. Because to take a decision on you, we need to hear you, and I'm sure you followed previous discourse, by this panel, and just feel free. After all, eventually when you get there and a case comes before you, you will now, juxtapose your own view against the reality that comes before you. On top of that, I would proceed with the follow-up from my respected colleague. The children out of wedlock are recognized by the law, but the women who bring forth these children are not recognized. Do you think that the law is being fair to those women?
Honorable members, before allowing my Lord to answer the question, we must also be careful the kind of question that we ask. Judges, by their nature, deals with the facts and the law. They don't deal with hypotheses. And my Lord has made it very clear that when the fact is before me, I'll look at the law, the case law, and then apply it to the facts. You may, however, answer this question.
Mr. Chairman, thank you. As much as possible, the law is there for everybody. The fact that the lady is cohabiting and there's no law covering cohabitation doesn't mean it should be thrown away. We'll look at the case on its merits and at least do something reasonable to take care of that person. We wouldn't definitely throw that person away, no. But we'll look at the case on its own merits and make sure a reasonable or a reasonable portion of the property is given to the person or taken care of. Thank you.
Yes.
Honorable Minority. Deputy Minority Leader, any further question?
Yes, I do. I know the justice, the nominee, is a very experienced man. And I would like to find out from you, what has been the most significant judgment or legal opinion you've delivered in your career thus far, and why does it stand out for you? I just wanted you to share that with us. Thank you.
Yes, Honorable Nominee.
There are a lot, but if I remember one, Entry vs. Abbey, which is often quoted, Entry vs. Abbey, where when it comes to adverse possession, I really define what adverse possession is and whether when there's a case before you and a chief is involved, whether it becomes a chieftaincy matter. I define that case is traveled all the way to the Supreme Court and it's very often quoted. And then another one is the Mozamadisco Crystal Church case in Sweden. I remember when I was in Sweden, the Akaboha. That's one other case. And then this case from, I think, Seshri yes, where at the end of my case, a chief was distilled and an Anglican bishop took over as the paramount chief and took off the cassock. They are interesting cases. Thank you.
I wanted you to share with us why you feel the ones that you've mentioned, really stand out. Maybe you must have a special.
No, Mr. Chairman, I took my time to explain the law, to expound the law, and it's so many times quoted by the lower courts. The other cases I wrote, there's other judgments in the Court of Appeal as well that are often quoted.
Right. Thank you. I'd like to know, normally when we are vetting nominees, when we are vetting them, we are presented with some of the interesting rulings that you made and judgments. May I know if you did present some of these, or you have with you some of these judgments which you have passed?
Honorable members, as a matter of fact, the nominees are here to answer questions from you. Questions were not given to the nominees in anticipation, as a result of which the nominee would have to bring copies of those excellent judgments that he has delivered there and then. So I will plead. Please ask another question.
Chairman, with respect, for anyone who has followed proceedings regarding justices of the Supreme Court, the record will bear us out that we've always requested for some judgments that they have written. With due respect to Chair, I do not think that asking such a question is really out of order, because my Lord is known, his industry at the bench. So if he's asking whether you have any of your judgment or any ruling with you, yes, obviously, Chairman, just allow. I mean, definitely appearing before us, it should be reasonably contemplated that a thing like that may be asked. Not that as a requirement, but obviously, since we want to know his views on the law, like the cases he mentioned, it would have been helpful if he had the judgment readily with us. Maybe, he could say he could furnish us some of his judgments later, but it's something that we've been demanding. This committee, check the records, Mr. Chair, so I do not think that it's out of place, but I think it's even an opportunity for us to say this to the nominee. There are 6 of you who are left, that at least if coming, they should carry along some of the very groundbreaking judgments that have defined their career. It's always okay to carry them along. It's good for learning. That's all I will say.
Honourable members, if the plea is to call on the nominee to make the judgment available later, I would have allowed it. But to say that do you have the judgment here without knowing whether the judgment will be requested or not, I believe that is not fair to the nominee. That's the reason for which I am overruling the question.
Honourable Chair, not to challenge you, but I'm just giving clarity to the question that I asked, because these are very interesting judgments that have been passed out there. So I thought it would be in our interest to have copies of such judgments. So if you can bring it later, I think we will appreciate it. Before the, Thank you.
Allow that if the question is a suggestion to the nominee whether he can make copies of those judgments available. But I still insist, if the question is, do you have it here? I would overrule that one.
Yes, thank you very much. Please, I will request that the nominee makes it available later before the decision is taken. Thank you. My last question, Honourable Chair. For the interest of everybody present, I think we know that in the judiciary, Ghana mandates retirement at 70. And in America, the US provides life tenure. Which of these two systems better serve judicial independence? And if I may ask, and why? And if I may ask, would extending Ghana's retirement age to 75 require some constitutional amendment? And would you support such a change? Thank you.
Thank you, Mr. Chairman. If I got the question right, whether it should be, if I got the question right, what, Madam, are you asking whether we should extend the age to 75?
Yes. Yes.
All right, thank you.
Thank you.
Before I answer this one, we were given requirements as to what to bring. That's why we were not asked to bring judgments. That is why it's like we didn't bring any. I didn't bring any, but I'll sort that out. Mr. Chairman, I will not agree with sending the retirement age of the Supreme Court or Appeal Court judges to 75. No. The retirement age as of now is 70. Madam, Superior Court judges retire on their salaries. I guess formally, you need to be advanced in age to get the experience and the exposure so that when you give judgments, it's respected. It's a solid judgment because you add in personal experience to the knowledge, the legal knowledge you have. But, Madam, with all respect, of late, technology has made it such that what you need 60, 70 years to know, technology can make it available to you very early. So personally, my opinion is to keep it at 70. That is my opinion, not to 75. I want judges to retire very healthy, and then we can use them for other purposes like assessors. They can help the judiciary or the service in other forms like assessors to filter our cases. So I think we maintain it at the 70 as of now. That is my opinion.
Thank you very much, and I wish you the best. Thank you.
It's now the turn of Honorable Minority Leader. Honorable Roxanne Nelson, Achida Famoko.
From him. Chairman, thank you very much. My Lord. Yes, sir. Weasel. The old students of HEBS, they've sent me a message to let you know that they are extremely proud of you.
Thank you. I thank them.
And they wish you all the best.
Thank you.
It's, my Lord, I want to ask a couple of questions in terms of policy and some forward-looking matters. The Constitution in Article 142, 143, and 144, 3, 4, and 5 thereabout makes provision for the establishment of the regional tribunals as part of judiciary. But there's been some hesitation, or not some hesitation, but marked hesitation to apply this provision of the Constitution. And I'm being compelled to litigate it for a declaration that the omission amounts to a breach of the Constitution. So let me ask of your opinion because of your background. How important would the addition of the regional tribunals to our current judiciary, the current structure of the judiciary, High Court up to the Supreme Court, serve the needs of the judiciary?
Thank you, Mr. Chairman.
Yes.
I am always for the tribunals, the setting up of the tribunals, because one, we say we have too many cases pending and the cases delay. If we set up more courts, definitely it's going to help alleviate that situation. And secondly, we shouldn't lose sight of the fact that the qualification of the tribunal chairman is the same as the High Court judge. It's just that two ordinary people who are not lawyers are to help him, assist him. So I don't see it's just the nomenclature, the naming, but the jobs done are virtually the same. And then more criminal cases will go to the tribunals because they wouldn't do civil. So it gives more chance to the mainstream court to have more time for civil cases. So I am always for the tribunals. We need more of them, especially the lower tribunals. Justice emanates from the people. Why don't we give them courts manned by the people from whom justice emanates? So I am always for the tribunals. And the Constitution says it has to be done. So it has to be done. Thank you.
Thank you very much. My Lord, I have been waging two wars. One in respect of the welfare of some judges, and one in respect of the welfare of law students, so to speak. So in respect of the judges, we have at the magisterial level, we have the career magistrates and what the judiciary has come to describe as professional magistrates, trained lawyers who have been elevated onto the bench from the magisterial level, and a program that produces magistrates with some structure to be attained as chief magistrates when you go through the ranks. What I have observed, having become a member of parliament, is that there are disparities in their conditions of service. Disparity in the sense that the career magistrates do not have official accommodation. They do not have official vehicles to assist them to work. Yet the professional magistrates, they have official accommodation and they have official vehicles. And my Lord, within the Labor Act, they do equal work. And the law is very clear. This House passed it that equal work must attract equal pay. So as a matter of policy, will you, the Judicial Council, consider aligning the conditions of service of the career magistrates to that of the professional magistrates as district court judges?
Thank you, Mr. Chairman. I remember very well when I was on the council last year, this issue cropped up and a committee was set up to solve the issue, to make them, to bring the parity. Just as you rightly said, they do the same job. So you are right to say that they deserve equal remuneration and the perks that go with it. So I support you, they deserve that. I think the committee is working on it. I don't know whether it's out yet, but it's being taken care of. They deserve what you are saying. Thank you.
Great. My Lord, my other war that I wage, and which I think the Judicial Council will have a role to play, is in respect of the legal reforms that we want in legal education. Some faculties have been accredited to run the academic programs. but they have not been accredited to run professional programs. But there's been a bloat in the number of the faculties that produce men that obtain academic qualification necessary for you to train as a professional lawyer. So our monolithic law school is inundated with the numbers. And I've seen hesitation on the part of the Judicial Council, which has very large membership on the General Legal Council, to advise that the law school, there should be, by way of license, so to speak, the faculties be granted the license to also train professionally, and then we can have one bar exams, whether twice a year or once in a year. The modalities can be agreed upon. But we need the faculties to train professionally as well as our law school as it is. When you get onto the Supreme Bench, will you consider by way of policy? Because every Supreme Court judge has the potential of acting as a Chief Justice at one time. Will you, as by way of policy, give this firm support that the law school, the faculties be permitted to train their products professionally, so one exams or test can be set for all of them?
Thank you, Mr. Chairman. I know Honorable Member is a very strong advocate for this. We have to weigh two things: quality as against quantity. I think there is, or there must be, some reason for which the law school at Makola is built near the court. Because I keep saying the court is the lab where you go to do your practicals. Yes, I agree with you that other professional courses, professions like accountants and others train elsewhere, whatever you want to train, and write one exam. I know that's what you are advocating for, that the faculties should be allowed. But the question is whether we can have control over the way they are trained. We don't just necessarily say because you pass the exam, fine, you are qualified to them. There must be some training sessions, some training procedures. It's a dicey issue whether all faculties should be allowed to train their lawyers and then they write one exam and they all qualify. If we have the facilities to regulate and make sure that they go by the...
But by way of assistance, will you be of a different opinion if the curricula is redesigned to capture the essence, the matters that...
Exactly what I'm saying. If that is done, and the faculties must be supervised to make sure that they attain that level of standard we need, fine, why not? Then they write one exam, and then when you pass, you become a lawyer. So I'm for it. But then we must watch the quality. Thank you.
My Lord Dzamefe JA, as his GSC soon to be.
Thank you.
I thank you for your answers. Let me also add that in your previous answers, I've listened to your concerns regarding the proposal to have time limitations for trials. The Rules of Court Committee hasn't done well in this matter. So let me inform you that by way of private members' bill, something is coming up like that to be called the Fair Trial Act. Yes. Now, my Lord, let me say this. I've seen that you've been on the bench from...
Honourable members, the fact that the Rules Committee have not done well should be expunged from our records.
Chairman, thank you very much. You've been on the bench since 1988, actually, for the records. So that's about 37 years as a judge.
Yes, Mr. Chairman.
And yet we are now considering for the Supreme Court. Congratulations.
Thank you.
I wish you all the best on the Supreme Bench.
Thank you, sir.
Thank you very much.
Thank you, Honorable Roxanne Nelson. It's now the turn of Honorable Minority Leader and the ranking member of the committee.
Chairman, thank you for the opportunity. Chairman, as you read in your opening statement, this committee is fortified by a letter from the President dated the 20th of May, 2025, which letter states as follows: that on 29th of April 2025, I submitted my nominations by letter to the Judicial Council for appointment to the Supreme Court. The chairperson, Acting Chief Justice Bafo Boni, on behalf of the Council, advised me on the 5th of May 2025 of the suitability of my underlisted nominees for appointment to the Supreme Court. The letter goes on. In accordance with my duty under Article 1442 of the Constitution of Ghana, 1992, I consulted with the Council of State by submitting the above names and their curricula vitae to the Council of State. Next sentence. On 7th May 2025, the Council of State notified me by a letter and a report indicating their suitability for appointment. Honorable nominee, from the President's letter, it is obvious to me that Council of State did its work within 36 hours or less. May I know from you whether you were contacted by the Council of State as part of their work before recommending you? May I know from you?
Mr. Chairman, I was not called by the Council of State to meet them, no.
Now, would you disagree with the suggestion regarding the speed with which the Council of State communicated back to the presidency? 36 hours. Council of State consultation. Do you find it rich?
Mr. Chairman, that one is beyond my
Very well.
control.
Very well. Now, as part of our own due diligence as a committee, we peruse your CV. And here, just to avoid surprises, I want to ask you whether you have your CV with you. Yes. You have it right with you?
Yes, Mr. Chairman.
In soft or hard copy?
Hard copy.
Very well. So we'll have a little exercise on your own CV.
Okay.
Good. So as part of the due diligence that this committee did, it attempted to validate some of the information by relying on other institutions of state. On the issue of educational background, item 1, Norwegian School of Management, Oslo, Norway, MBA in Leadership and Strategic Management. The state institution relied on to validate this could not confirm this for us. Are you able to provide us with the certificates and the transcript of this qualification you've so provided yourself?
Yes, I'll do that. I can. Then the state agency you relied on didn't do a good job.
Yes, we relied on the NIB. They wrote to us formally.
I schooled there, and I can provide you the necessary things you want.
The NIB wrote to us formally. Now, let us, so you agree that sometimes our state agencies make mistakes or they fail us. You agree with me on the basis of this? Since you said they didn't do a good job. Obviously, that's the result. Anyway, let's make progress. This program, you've stated that you did it between 1994 and 1995. Was it a scholarship from the Judicial Service, full-time program? You took off your work as a judge and pursued in Norway, or it was some correspondence or part-time?
Mr. Chairman, this is a full-time course. I was given scholarship by the Norwegian government. In 94, 95, when we were integrated into the mainstream judicial service, we were not working. So I took the opportunity, took permission from the service, and went to pursue this course and came back after a year.
So the scholarship was not routed through the judicial service?
No, it was the Norwegian government scholarship.
Did you apply for it?
Yes, I did.
Very well. Now, you've answered the question regarding the number of judges at the Supreme Court. Are you sure they are 13 and not 14? I'll give you the time to reconcile that. We'll come back.
What if yes, okay, if you give him the time, I can refer to our diary and see the correct numbers.
Yeah, sure. That's what I'm saying. I'll give you time to reconcile that. Now, still on your CV, you went to the training college.
Yes, Mr.
After
Chairman.
the O-level.
Yes, Mr. Chairman.
Then just after the training college, you went to the university from the records and the dates you provided.
Yes, Mr. Chairman.
So,
I taught for a year before going to the university. Yes, before going to the university. After I finished training college, I taught for a year. Within that year, I went to the university.
So you taught for a year, but you've not indicated the school you taught. You've not indicated that on the CV.
But that was in Pando in 1978.
Very well. Because, so when did you finish the training college? Which you say 75 to 78.
Yes.
The academic calendar, do you readily remember which month of the year you completed your program at Jessica?
I think we finished in June, July 78, and I was posted to Pando Gabi LA Middle School. I taught in that school until November, December, when I went to the university.
Okay.
So you can check from the Ghana Education Service.
No, my lord. If you say I can check from Ghana Education, that's fine. No, I'm
not you personally. Yes, we can cross-check.
No, I'm dealing with your CV. I'm dealing with your CV. So that's why I said, do you have it with you? A little bit of patience would help. Okay, so it's your own record. It is not anything hypothetical. So now, according to you, 78, you were done with training college around July. You were posted and then you taught up to December, correct? So that ends 17/8. Then you have here LLB, University of Ghana, Accra, Ghana, LLB, Hans. Then you say 79 to 82. So I want to know from you, the 79, which month, if you recall, did you start your first academic semester?
Mr. Chairman, I finished training college in 78, was posted to Pando Gabriele Middle School. I was a teacher there and entered the university the following year, 79. We started, I think, in September 79. I didn't enter the university in 78. I entered in 79, sir.
My Lord, I didn't say that you entered the university in 78. I haven't said that. You said you taught up to December. The records would bear me out. That's why I repeated it just for clarity. No, so you relax, be with me here. Be with me here. There's nothing to worry. It's your CV we are perusing. So when you were done with training college in July of 78, your earlier answer was that you were posted to a school in Pando and you taught in that school up to December of 78 and entered university, please. Entered university in 79. Please clarify.
Thank you, Mr. Chairman. I taught for a year in Pando, that's 70, and entered the university in 79. I went to Jaskan Training College in 1975. We were the first batch of a 3-year post-sex. Finished in 78, and I was posted to Pando Gabi LA Middle School, where I taught for 1 academic year. And in 79 September, I went to the university. So if Mr. Chairman, the CV says 79 to 82 to the university.
Yeah, so it means that your earlier answer that you taught up to December.
I don't remember. Did I say that?
Yes.
Oh, then I'm sorry.
That's why I came back.
Then I'm sorry.
Yes, that's why I came back for you to reconcile.
No.
Okay, very well.
Thank you.
So, my Lord, you also said, you stated on your CV, you said you went to training college after your O-level. Now, I am aware of Cape Coast University those days. They would admit A-level, SS, professional, or mature students. Did you enter the university with your O-level certificate, or you entered as a mature student, or with a combination of your post-secondary certificate, that's your training college certificate?
Mr. Chairman, I entered with 3 A-levels, not post-sec degree certificate. I wrote the A-levels whilst in the training college. We have adult education courses there, and I had 3 papers before entering the university. I wrote the A-levels in the training college, and that's what I used to enter the university.
Which subject did you do for your A-level?
Economics, religion, and geography, and then general paper.
My Lord, you said you only speak English and Ewe, correct?
Fluently, correct.
But you stayed in Aguna Sudro for more than 6 years, and my Lord did not make an attempt. Is that the case?
At least I can speak some little, like yours, Abazi. I can say that one.
My Lord, but Aguna, they speak Aguna. Aguna Sudro, they speak about it.
Well, I wrote English and Ewe because those ones I can speak fluently.
So, but the tree, we are there on kakanga.
I understand you, but let's keep it there.
Very well. My Lord, let's do a little exercise on Article 126. Okay, let's go there. Please, you have your constitution with you. My Lord, you there?
Yes.
Very well. In your earlier submissions, you indicated that Superior Court justices retire on their salaries, correct?
Not yes, but not fully because you need to do a number of years.
Okay, so if you say you need to do a number of years, let's bring clarity to it. Superior Court justices are in three categories: Supreme Court, Court of Appeal, and the High Court. Correct?
Yes, Mr. Chairman.
Now, which of these categories? Four: Regional Tribunal stroke High Court, Regional Tribunal Chairman stroke High Court. Very well, it's the same thing. Three. I don't want to talk about Regional Tribunal. I'm not interested in the populist revolution thing. I'm not interested in that. I won't go there. I won't mention Regional Tribunal. I will not. You can do your own thing. I'm not interested in tribunal where you use your aura, abuse people's rights. I'm not interested. I'm dealing with
Honourable members, order.
Chairman,
the reference is to Article 126.
Very well, let's
the
proceed.
judiciary shall consist of the Superior Court of
Chairman, I'm able to read.
comprising the Supreme Court, the Court of Appeal, the High Court, and Regional Tribunal. So you cannot say you are not interested in the Regional Tribunal when you are making reference to Article 126.
Chairman, thus far we've had some peace. Restrain your chief whip. We kept quiet for him to ask all his questions anyway. So, which of the categories is the number of years of service applicable to?
Mr. Chairman, some people join the service from after civil servants who have retired. For example, there were 60 where they were working before joining us.
My Lord, I'm not stopping you. I'm not stopping you. Please. We may stay longer depending on your approach. We may have a very short session if we deal directly with the issue. And that's what I would prefer, the latter approach. So please bear with me. We know the Constitution defines three categories: Supreme Court, Court of Appeal, High Court / Regional Tribunal chairs. And in your answer, you qualified the earlier position you are taking, that Superior Court justices retire on their salaries. You qualified it by saying that, yes, but it depends on the number of years of service. I want to know from you, of the three, High Court, Supreme Court, Court of Appeal, which of them is this number of years applicable to enable them retire on their salaries?
Mr. Chairman.
Or is applicable to all?
It's applicable to all.
Oh, I see. So, for instance, if a person is nominated to Supreme Court and he serves only 4 years and retires, is it the case that he would not qualify to retire on a salary? Is that the case?
Mr. Chairman, it depends on the number of years you've done the civil and the public service before joining.
So let's be specific. The person, the person came from the bar. He's a private practitioner who was nominated, a professor, a private practitioner from the private sector, a businessman, someone who has worked with corporate Ghana and not in public service or civil service. Please, I'm done. Yeah.
Mr. Chairman, what I know and what I'm saying is that if you are from the public service and you join the judiciary, if you do 10 years as a judicial officer, you retire on your salary. But if you join from outside and you don't do the 10, if you do 20 years before coming, will be added, and then you qualify. It's a constitutional provision.
Please, okay, they are saying Article 155 from here, if you may read that aloud.
Mr. Chairman, it states that notwithstanding the provision of this chapter, a justice of the Superior Court of Judicature who has attained the age of 60 years or above shall, on retiring, in addition to any gratuity payable to him, be paid a pension equal to the salary payable for the time being to a justice of the Superior Court from which he retired, where A, he has served for 10 continuous years or more as a justice of the Superior Court of Judicature, or he has served for 20 years or more in the public service. For 20 years or more in the public service, at least 5 continuous years of which were as a justice of the Superior Court of Judicature. And upon retirement under the clause, he shall not hold any private office of profit or emolument, whether directly or indirectly.
Honorable nominee, may I know from you whether, in view of the provisions in Article 126, having regard to your earlier position that to enable the court function properly, human resource is critical. That is, judges and officers of the, staff, judicial service staff must be paid well. Would you recommend a constitutional amendment which will incorporate the lower court justices, i.e. district magistrates, circuit court judges, to come under this provision of retiring on their salaries? Would you recommend that?
Mr. Chairman, this depends on the kitty. I wouldn't recommend that. I think this is an incentive for you to work hard and enter the Superior Court. I think it's a way of rewarding you for your hard work. So I wouldn't recommend that everybody falls into that category, sir.
Now, Superior Court justices come under Article 71 office holders, correct?
Yes, Mr. Chairman.
So, High Court judges, Court of Appeal judges, and Supreme Court judges every 4 years enjoy the Article 71 emolument, correct? Every 4 years, correct?
When you say emolument, every 4 years they enjoy the emolument, I don't understand you. Judges, our salaries are not reviewed every year. It's done once in 4 years. So what is paid back is the difference. That is what is paid every 4 years.
Let's go to Article 71. Lord, let's go to Article 71. Yeah, my Lord, if you may read 71 for us.
Okay. All of 71.
Rightly so.
The determination of certain emoluments, 71. The salaries and allowances payable and the facilities and privileges available to A, Speaker and Deputy Speakers and Members of Parliament, B, the Chief Justice and the other Justices of the Superior Court of Judicature, 3, C, the Auditor General, the Chairman of the, and Deputy Commissioner of the EC, the Commissioner for Human Rights and Administrative Justice and his deputies, and the District Assembly's Common Fund Administrator, D, the Chairman, Vice Chairman, and other members of D1, National Council for Higher Education, howsoever described. 2, the Public Service Commission. 3, National Media Commission. 4, Lands Commission. 5, National Commission for Civic Education. Being expenditure charged on the consolidated fund shall be determined by the President on the recommendations of a committee of not more than 5 persons appointed by the President, acting in accordance with the advice of the Council of State. 2, the salaries and allowances payable and the facilities available to the President, the Vice President, the Chairman, and other members of the Council of State, Ministers of State, Deputy Ministers, being expenditure charged on the consolidated fund, shall be determined by Parliament on the recommendations of the committee referred to in Clause 1 of this article. For the purposes of this article, and except as otherwise provided in this Constitution, salaries includes allowances, facilities, and privileges, and retiring benefits or awards. Thank you.
So, back to your earlier position, you said that every 4 years, when this committee meets and makes recommendation, because your salaries are not done yearly, they make recommendations and you are paid salary arrears, correct?
Yes, Mr. Chairman.
Which is known on the streets as emolument.
Yes, Mr. Chairman.
So, you disagree with any suggestion to the effect that Article 71 is only there to benefit the political class from the reading you have just made? From what you have just
Mr.
read.
Chairman, what the Constitution says is what it is, not the interpretation people put on it. This is not, it doesn't mention a political class here. It mentioned the categories of people who should enjoy this Article 71 emoluments.
Yes, so I'm saying that from what you have just read, those to benefit from Article 71 is not limited to the elected political class. That's the point I want to make from what you've just read.
Yes, I think you are right.
Correct. Now, my Lord, I want us to go back to an earlier position taken by my respected learned colleague, the leader of the House, Honorable Ayarga. he relied heavily on the CJ, Justice Araba Isaba Tokono's recommendation to suggest to you that there's really nothing wrong in increasing the numbers at the Supreme Court. And you seem to have agreed with him, correct?
But the reasons given by the honorable man, I said yes.
Very well.
Because I haven't seen the article she wrote.
Very well. Yes, of course, he quoted from the copiously from the letter. Now, you would agree with me that this proposal led to a public outcry. But now, we are adding 7 more to the same court. Would you, as a beneficiary of this, would you say that that criticism was unfounded?
Mr. Chairman, if I got it right, it's the Judicial Council that raised the first criticism. The Judicial Council, if I got it right, that the names didn't originate from them. That is all I know. So it was not like I am a beneficiary of, like the word you use, beneficiary. No. I was nominated by the President of the Republic to become a Supreme Court judge. I don't know whether it's based on an article or anything. I just was nominated, Mr. Chairman. So I cannot tell whether I'm a beneficiary or people, no.
My Lord, the argument was to the effect that the Supreme Court, the highest court of the land, was being packed. And in fact, a colleague of yours who had been vetted, I think my lady, is it Benasco, wasn't? Yes, I have here. Your colleague, Justice Sophia Rosetta Oduokua Benasco Esa, who had been nominated, vetted, and a report submitted to the plenary. As a result of this rather loud disagreement, Parliament could not even take the report. And
Please continue.
the loud disagreement, including threats on the floor, that laying of the report would generate chaos, eventually prevented the laying of the report. I want to know from you that in view of the argument that even these two adding to the Supreme Court would amount to packing, would you now disagree with that opinion that this 7 being added, of which you are a beneficiary, worsens the matter?
Well, before allowing the chairman of the committee to answer the question, I would ask that the issue of a threat to the laying of the report be expunged from the question. Please proceed to give an answer.
Chairman, I speak of the record, though I will respect your ruling, but I will pull the Hansard. Fortunately, my respected colleague who used a word, there will be chaos. Hansard captured him. If you are ruling it out now, I don't mind to take that one out, but I will bring the Hansard to just, we are not done yet, so I would bring it, so at least once there's a record.
Honourable members, I believe and support the principle that matters that happen on the floor of Parliament is a closed book. Please proceed to give your answer.
Thank you, Mr. Chairman. I'm not even privy to all that happened in Parliament, whether there was chaos or there were threats. I don't know anything about that. I have just been nominated to the Supreme Court. I don't know anything as to whether I benefited from anything or I don't know, Mr. Chairman. I can't exactly tell what happened on the floor of Parliament. I don't know. That is what I can say, Mr. Chairman.
My honorable nominee, did you become aware of the general apprehension in the public space regarding the 2 nominees as same amounting to the packing of the Supreme Court? Did you become aware of the general apprehension in the public domain at the time?
No, Mr. Chairman.
Okay, fine. Would you disagree with any suggestion to the effect that these 7 nominations from the president at a go amount to the packing of the Supreme Court? Would you disagree with that suggestion?
I think you answered this question, said no. So why is the question being repeated? So, Honorable Minority Leader, with all due respect, proceed with another question. He says no to it.
Honorable nominee, the Supreme Court of Ghana has not been capped by any constitutional imperative, correct?
Yes, sir. Yes. There's no cap.
You would therefore agree that circumstances may result in having a certain number on the bench, correct?
Yes, sir.
So, in view of that, you would disagree to any suggestion that seeks to condemn or criticize or create a certain apprehension when nominations are being made with justifications for the number to go up to a certain point. You would disagree?
Mr. Chairman, it depends on the justification. It depends on the exigency and the justification according to the nominations. Thank you.
You will agree with me that the current 7 nominations have not been accompanied with any verifiable justification or exigencies. You would agree with me?
Mr. Chairman, I'm not appointing authority, so I wouldn't know why. So it's difficult for me to answer why.
Chairman, I want to register a protest on record. I know that you are not sharing your power. I would plead through you to my respected colleague seated immediately to your right. The interjections, though not on record, those interjections are becoming too loud and too many. And we've started well. The man seated there, I've appeared before him, and he knows me very well, and I know him very well. We are discharging a constitutional duty. If it were to be on personal level, I say, my Lord Dzamefe, please, I've passed you. We are doing a constitutional exercise, and we have political views on certain matters. You've had your turn. This thing that we do, then it get out of hand, the public misconstrue us. I don't want it to happen. Please restrain him. Please restrain him. It must not continue.
All other members are accordingly restrained. The floor is given to the minority leader and the ranking member of the committee. So
you must add or sign to be say that.
No, this attempt to run me under the bus, I won't accept it. Were you not interjecting? Were you not? Did anybody protest? Please.
You have the floor. You have the floor. Please continue with your question.
You can't run me down.
Honorable nominee, may we do some exercise on constitutional evolution and textual fidelity? In your view, when should the Supreme Court adapt constitutional interpretation to changing circumstances, whereas at the same time, a view regarding adhering strictly to original text has to be complied with? And maybe let me hear you on that, then I can do a follow-up.
Mr. Chairman, the Supreme Court, as the apex court, is a policy court which we cannot deny. That is why they are not bound by their own decisions. As at when they think fit to do so, they can depart from their decisions based on the evolving nature of the law and situations. So the Supreme Court, saying that something has to be done, are at liberty to depart from their previous decisions. That's why they are not bound, Mr. Chairman.
Can you provide an instance where you would favor evolution and one where you would insist on textual fidelity? I know I have a textualist right by me, but who am I to even say he's seated to my left or right? I have a textualist with me.
Proceed to ask your question. Nobody seated by you has the power to interpret the Constitution. Ask your question.
So may you provide an instance where you will favor evolution and an instance where you would insist on textual fidelity?
Mr. Chairman, if the Supreme Court gives a decision, we are all bound by it. But then, when you can depart when the decision is given per incuriam, or a wrong law has been applied, or the decision becomes unjust in the circumstances. And if you can differentiate the facts, you can depart from it, Mr. Chairman.
Honorable nominee, let's talk about judicial ethics and independence. Would you be able to give us 3 specific measures you would implement or you suggest to be implemented to maintain judicial ethics whilst preserving independence?
By the ethics of our job as judges, 1, you go strictly by what is before you, that is the evidence before you, and the facts. If I got the question right, you base your decisions on the evidence and the facts before you. You are not to depart from this. And then if it's I don't know whether it's the social aspect you are asking, your comportment, your rapport with lawyers who appear before you, it's there. You must know how you relate to parties who appear before you, the language you use in court, comportment, as I said earlier, your punctuality, even your own outlook as judges. And then you must not meddle into politics. You must be independent. You must just give out your mind. You don't care whether it's coming from A or B. These are some of the ethics we go by. And then you must know where you go and where you don't go, where you are seen and where you are not seen. Thank you.
So in view of that, how would you then balance the question of transparency with the need to avoid inappropriate commentary on legal issues?
You just have to know how to balance it. It's a thin line. If you heard me earlier, I said comments and opinions passed by judges carry a lot of weight because you don't know when a case will come before you. So you have to be very sparing as to comments you pass because, 1, a case may come before you and the facts may be different, not on all fours. You have to depart from what you said. Even some people can even petition your recusal from the case because of a comment you once passed. So you have to be very careful as to the comments you pass as a judge because it carries weight.
Now, you are aware of the ECOWAS courts. You become aware of the ECOWAS courts, my lord.
Yes, Mr. Chairman.
And you've equally become aware of other judge-made laws in other jurisdictions that sometimes lawyers appearing before you may rely on for persuasive purposes, etc.
Yes, Mr. Chairman.
Now, in your view, should foreign constitutional precedents influence Ghana's constitutional interpretation?
Mr. Chairman,
if I may add, just to make it composite, when, if ever, should the Supreme Court cite decisions from, say, South Africa, United States, United Kingdom, or even ECOWAS court decisions? I may take it again if you want to take down the question. Are you okay? Okay, proceed.
Mr. Chairman, any decision from outside is persuasive. It's not binding on us. But then, for sake of best practices, we are not a committee of nation. We belong to a committee of nations. Sorry, we are not an island. You can learn best practices from other areas and import into the law, but that should not override your own laws, because whatever comes from outside is persuasive. Mr. Chairman.
Now, on the issue of democratic theory and constitutional purpose, I want to know from you, do constitutional term limits serve primarily to prevent individual power concentration or to ensure democratic competition, in your view?
Mr. Chairman, I don't understand.
I'll repeat.
The question. Yeah.
I'm saying that I'm now delving into area of democratic theory and constitutional purpose. And my question is, in your view, does constitutional term limits serve primarily to prevent individual power concentration, or it is there as a constitutional imperative to ensure democratic competition?
Can you give me some examples, please?
Yes. The example is that, for instance, in Ghana, there's a constitutional term limit that, okay, for the presidency, your term, 4 years, you can go again. And you earlier answered it when you said somebody was trying to, my colleague John Dakun was suggesting to you that, does that mean consecutive terms? And you said the Constitution says 2 terms and that's it. Of course, we've had Professor Kwesi Prempeh, the chair of the Constitutional Review Committee, being very clear that 2 terms means 2 terms. Now, with that background in mind, what I'm asking you to share a view on is whether or not this provision is there to primarily prevent individual power concentration, or is there to ensure democratic competition? Is it clear now?
It's clear. Mr. Chairman, what the Constitution says is the law. Whatever you say beyond the Constitution is noise. And no matter the many noises you make, the law is what? It's the law. You can't read any meaning into it apart from what the law says, Mr. Chairman. It says 2 terms. And whenever the Constitution gives a term limit, you have to follow it, Mr. Chairman. Unless it's amended or repealed, you don't have a choice. There's no other interpretation you can give to it than what it is, Mr. Chairman.
My Lord, you have earlier expressed a view on interpretation methodology, and you ran us through the various issues to consider. And I think I heard Honorable Ayaruga commending the view expressed and invited the students to pay attention to that. Having given that view, and I would want to ask you this. Ghana, which sometimes can have politically sensitive cases, should the Supreme Court err towards restricting or expanding executive power when text permits multiple interpretations? And if so, what factors will guide that?
Mr. Chairman, I've said this several times with all respect, that what the Constitution says is what should be done. I don't know what more to add, sir. If the Constitution says 2 terms, I don't see how a different interpretation can be put to it. Mr. Chairman, I don't know what, that's what I think, sir.
My Lord, your colleagues who came before you, especially during Kufuor's era, had cause to give a certain interpretation to the Constitution. And just for our purpose, I remember that in looking at the law, they suggested, they made a strong point in their judgment to the fact that once the president is out of the jurisdiction, there must be someone in the jurisdiction to act. And the person must take the judicial oath. Now, it's been long. This ruling or judgment has been in our books for so long a time. It's like what we previously, as lawyers, were adhering to, that when an injunction application is filed, though it has not been determined, once you've been served, you must not do anything to disturb it. And we're going on with this for a long time, till recently in the Cohabitation 3-2 decision, my Lord Kulendi, writing the majority opinion, said no, there must be express order from the court. That is now the new law without any ambiguity, and says that constitutional bodies must be allowed to do their work and all. The nation has heard you, the court, on this, and we would abide. Now, having given you this sufficient background as to precedent, may I know from you whether, in view of technological impacts on the practice, and you've talked about AI this morning, on repeated occasions, in view of technological impact, having regard to Article 68, would there be a requirement for the Speaker to take presidential oath when acting in the absence of the President and the Vice President?
Mr. Chairman, if the law says he needs to take an oath, he has to take it. If it doesn't say so, then he doesn't take it. Thank you.
But does the law say so? The Constitution says so, that he must take an oath when acting as president. Take the presidential oath. Does the Constitution say so?
Yes.
Lord may guide us with the particular exact provision, please.
If you see, I think it's Article. Well, I can't get it offhand, but Mr. Chairman,
we can look at it. You can take your time and provide that later. But you can furnish us with that later. But my Lord, my question directly related to this is that in an era of instant global communication, does this distinction remain constitutionally necessary, and should, quote, absence from the Republic, unquote, be redefined in your view?
Mr. Chairman, with technology now, absence, it has a different meaning now, because a case came before me as to the meaning of working from home, as to whether during the COVID time, working from home, whether it's from your house or from outside the workplace. I think if the president, this is my opinion, please, if the president should be out of the country, let's say for one day, and coming back, yes, the Constitution says there should be no vacuum. But if the person if the technology can make you work from outside your office, but well, the law says if you are out of the jurisdiction, fine. But if you are in contact with those who you work with, I don't really think, and the period is that short, maybe one day, I don't think there should be this ceremony when you are coming back the following day for somebody to swear an oath, and then the following morning the president or whoever's oath is taken is back.
Is my law departing from the law? Is the law?
The law is the law, but I'm not departing from it. But what I'm saying, this is my personal position. Mr. Chairman, what I'm saying is that, let's say the president goes to Nigeria and will come back in the evening. He's not in the country, but that does not necessarily mean that the vice should take an oath to act for him when he's coming back in the evening. I mean,